Adjournment request, if any, from item number 1 to 7. From item number 8 to 14. From item number 15 to 25.
I beg to mention item number 16 and for the respondent, Lordship, I've taken consent from the other side.
Yes, last time also it was adjourned on your request.
Lordship, I've taken only today password.
Huh?
Only for password today, my lord. Yes, on this
Password today. Yes, who is for the other side?
That's it. I've taken consent. Sir, I'm sorry, my lord.
After a week. After a week.
Lordship.
Yes.
Maybe, Lordship. Lordship, with consent of other side, I beg to mention item number 25 and 26. My senior Mr. BC is out of station.
26 and 27.
25 and 26, Lordship.
25 and 27.
26.
You are for the
Petition line.
Sure. 4 weeks. Yes.
No, please, yes, Your Lordship. Lordship, I beg to mention item 21. Your Lordship, this is a PIL, Your Lordship. On the last occasion, Your Lordship directed us to collect some data. We need
Give some better particulars.
Yes, Your Lordship. We need 3 weeks time, Your Lordship, to
Now the
collect.
situation is almost over. We asked you how much compensation the government has provided.
Yes, Your Lordship, we
Was
will
the-
collect that data.
So where is those details?
Your Lordship,
Where are those details?
we are collecting it, Your Lordship, so we must.
Still you are collecting, it's almost 4 weeks. Okay, then concept of the petitioner, please, some more time to bring better particulars in support of the writ petition. List after 6 weeks.
3 weeks, Your Lordship.
6 weeks, yes.
Deeply aware.
May it please the Lordship. Lordship, I request for a listing of a fresh matter which we have filed on 12th of July. Matter may be taken up tomorrow. Matter pertains to a surface cement. Where we have been,
Surfacing matter, what?
Lordship, there's a legal point where it needs to be discussed whether there are two properties. One is commercial and residential. By order of the
That is surfacing matters mein 226 writ is not at all
Lordship, some
maintainable.
indulgence
There
may
are
be given-
Supreme Court judgments. Still, if you want to.
Tomorrow,
get it
Lordship,
listed,
kindly.
not tomorrow,
Day
day
after
after tomorrow.
please, your Lordship, please.
And mind it, come prepared.
Yes, your Lordship.
Yes.
Yes.
But in item number 28, my affidavit, they are bringing it today. Kindly give it 2 days time, not by, I'll try to file it by today. Item number.
What
20,
affidavit?
This is a PIL, regarding construction of roads. Our instruction is that more than 55% work has been done.
The time limit was up to March 2024. Completion of the road.
True. Malad.
Then
Let me,
still it's only 40%.
it's 55% they said. 55%. Yes, sir.
Your Lordship, my instruction, I have got photograph of the 4th of July. These are the, I will file affidavit, Your
Yes.
Lordship. Only
Let
10,
Let them
me
file
bring
their
it on record.
response after a
Let me
week.
bring it on record.
After a week.
Lordship. Oh, problem.
May it please the Lordship. Lordship, I beg to mention 2 matters of the hearing list, Lordship.
Yeah.
Item number 9 and 10,
9 and 10
Lordship. 9 and 10 of the hearing list.
hearing list. Yeah, what do you want?
Lordship, these 2 matters have become infructuous. So Lordship may close the matter.
What is that hearing list? You are for the petitioner or appellant. These are appeals or
Read petitions.
writ petitions. You can then consider for the petitioners. Submits that these writ petitions have become infructuous, dismissed as infructuous.
9 and 10.
Yes,
May it please your Lordship. With the consent of the other side, I beg to mention item number 39 and 40, Your Lordship.
these are the hearing list.
Yes, sir. Not the hearing list, daily list, Your Lordship.
This is the listed for hearing.
Yes, Your Lordship.
Yes.
In this matter, senior counsel Mr. B. Datta is appearing. He hails from Tinsukia. due to some personal difficulty, he could not appear today. Can it be on
Okay,
22nd?
we'll not take up these matters today, but it will remain on the board. Yes. Yeah, ठीक है, pass over for-
Daily list for orders item 1.
Please, Lordship. Lordship, we have taken steps on respondent 7 on,
Respondent number 7.
we have taken steps on respondent 7 on 25, 2024.
But there is no office note of it. 18.5, no steps in respondent number 7. 24/6. Notice registered daily. You see this one, right? Notice for registered daily issued to the respondent number 7 by memo number 7 from either AD. Await return of notice of respondent number 7 for 3 more weeks.
Wait, Lordship, by order dated 28 June, they were asked to serve a copy to us. We are respondent number 426, but yet they have not served us extra copy.
Sir, why you not serve the copy?
Kindly allow us to file an affidavit in reply.
Allow us to,
File an affidavit in reply.
you are for the,
Extra.
you are for the petitioner.
Yes, my lord.
Why don't you supply the copy of the writ petition to the respondents?
You have to give them copy, read petition copy you have to give.
Await return of notice of respondent number 7 for 3 more weeks. In the meantime, counsel for the petitioner is directed to supply the copy of the writ petition along with the documents to the counsel for the respective respondents. Yes,
All right, sir.
within a period of 1 week.
Item number 2.
Respondent number 7 is not, respondent number 1, you are appearing.
No, Lordship, wrongly, his name, Mr. Mazumdar name may be deleted. He is not appearing in this case, Lordship.
Then who is appearing?
No, nobody has appeared. Lordship may allow me to take, throw Dusty, Lordship. We have already taken steps by register post, but service report,
Dusty,
because in the condonation stage also we served by Dusty, Lordship.
देखिए, as per the office report, the AD in respect of the service of notice upon the respondent has not, sole respondent has not been received till date. Full stop. Then it, counsel for the appellant is permitted to file fresh requisition for service of fresh notice upon the sole respondent through registered AD as well as Dusty.
And name of Mr. Mazumdar may be deleted. He is not appearing in this case.
शुरू में लिख देना, Mr. Majumdar is not appearing on behalf of the respondent, the sole respondent. The, उसके बाद में ये सारा लिख देना. Returnable so and so, so and so.
Item 3.
In this matter, my lord, tax has been deducted and it has been deposited, my lord.
Yeah,
Tax has been deposited, but there was some departmental matter to miscommunication. So income tax has made a demand to the petitioner, my lord. But while as a high court judge as well as loco acto, my lord, tax has been deducted and deposited, and they filed the affidavit, my lord.
so the court has granted stay on 4/5/2023 and
Yes.
prior to that they have deducted. What happened?
Well, now they filed the affidavit, my lord, The High Court, as a local actor, they have to produce the challan, my lord, by which they have deposited. Now, income tax department can adjust it and, my lord,
So it has become infectious now if he deposited.
they can adjust, my lord. If anything is pending, my lord, after that, petitioner will deposit.
Tax was deducted during the tenure.
Tax was deducted in 2008, 9, and then up to 13, 14, my lord.
Yes, sir.
Oh. Lucky, you can also the same. Communication there is 16A to issue permit. 16A to give like that. Itu আমার টিটিও নহয় মানে হয়তো অন্য বোম্বে করে খুঁজলে High Court is concerned only one amount, madam. High Court is concerned only one amount, which is shown at page 74, madam. They have deposited 77,301. And the rest is of local actor.
So this demand was raised on the premise that the TDS was not deducted.
Yes, but TDS has been deducted. And in fact, my lord,
Yes, Mr.
First, actually, I could not note the file because my name was not sought, and this is the matter. And Lordship,
You should have said it earlier.
no, Lordship, actually, today I've informed the department also, and the affidavit filed by the local that way by the High Court was not served loss, so we could not verify the amount. Initially, Lordship,
They already said that the same was deducted, then you have to cost as notice or cancel that notice.
no, Lordship, we have to verify because earlier it was not reflected in the account of the petitioner.
Whatever it may be, once
Now let's-
the affidavit is there,
No, now the affidavit in file copy, we have
Yeah.
not. Let me take up next week, I'll verify from the department and file.
list this matter after a week while showing name of Mr. SCKL. Counsel for the
Income tax return.
revenue. Stop. The counsel for the respondent number 5 and 6 are also directed to supply the copy of their affidavit in opposition to Mr. KL during the course of the day. List after
Much.
for
At-
admission, list after a week for admission, है ना? Admission.
Item 4,
Kindly pass over the matter for the time being, Lord.
My lord, here, my lord, we are
Click
filing
off.
the affidavit today, my lord. So let me file the affidavit, my lord. Lordship may consider in the next week, my lord. Oh, my lord.
What is the reason for delay?
My senior is coming, but he is stuck in traffic.
Yes, what objection you have?
My lord, here, my lord, the question is that whether he will get the benefit under section 12(2) of Limitation Act, my lord, because he has applied for a certificate copy after expiry of the limitation, my lord, 30 days. So, my lord, he applied on 30/8/2023. And the judgment is of dated, my lord, 8/6/2023. And in that view, my lord, some decisions are there. If a certificate copy is not applied within the period of prescribed limitation, then the time taken for certificate copy from the date of applying to the date of delivery, he will not get. In that view, my lord, limitation is more than 101 days. It is as per our 140 days. So we want to bring that contention, that affidavit, we are filing within the course of the day, my lord. Affidavit is ready, my lord.
Yeah, delay the condone will, here the
Let me
matter on
file-
merits. Was the
No, let
problem?
me file, my lord. Next week, lordship may
We'll
consider.
take your affidavit on record, and we'll record your objections. It will condone the delay. What's the problem?
My lord, yes, my lord, one judgment is on this point because he has to file a fresh one. Because my lord, he has
He-
not applied.
Decided on merits.
Yes. Next week, my lordship may kindly take, my lord, and let me file the affidavit. I pray, my lord.
On these technicalities, let the matter be decided on merits. What's the problem in that? It's after a week.
My lord, obliged.
Hello.
Come on, number.
item 5,
Obliged. Come on, phone number.
May I please? As per the report of the Lojima Court Service upon all the respondents. have
5, 6,
complained.
7, 8, 9, 10, 11, 12, 21. Yes.
My lord, I have filed a Okalatama for some of the respondents and appearing for that. So my lord, I pray 4 weeks time
And
for
you
file
are
the-
appearing for
I am paying for respond number 1 to 2.
1 to 4. So all the respondents have been served.
My lord, I pray 4 weeks time for filing my affidavit.
As per the report of the Lauzima Court, notices upon the respondent number 5 to 21 has been duly served. Stop. Mr. So-and-so is appearing on behalf of the respondent number 1 to 4, and Mr. So-and-so is appearing on behalf of some of the respondents. Please some time to file counter to the writ petition. Time paid for is granted. List after 4
Obliged.
weeks for admission.
For hearing, my lord. A matter has already been admitted.
Which matter?
This-
Similar matter.
My-
This matter has already been
matter.
admitted. List for hearing in due course.
My lord, may I pray, my lord, instead of due course, my lord, any in the month of.
Sir, if the matter is admitted, it has to be listed in due course. That's all. Move an application if you want an early hearing, move an application, we'll fix a date.
My lord.
Item number 6.
Well,
Yes.
I is for condonation of delay, well, the respondents, they have appeared.
How much delay?
283 days delay, well,
Was the judgment?
the similar order, well, against the judgment, similar appeals, lordship has already admitted, well. This is regarding compassionate appointment.
Compassionate appointment?
Yes, well.
Yes.
We have not declared.
Can Mr. So-and-so put an appearance on behalf of the respondent number 1? The sole respondent number 1.
Yes, well.
This IA is preferred on behalf of the appellants with the prayer to confirm the delay of 283 days in filing the connected rate appeal. Then it consent for the applicant has submitted that against the impugned judgment, identical appeals have already been admitted by this court after condoning the delay. Would stop. Then it consent for the sole respondent has not seriously opposed the IA. In such circumstances, the IA is allowed delay of so and so days is condoned. Unless the registry is directed to register the connected appeal and just before this court for admission after a week.
Item 7.
Respondent number 2. Who is appearing for the respondent number 2?
I'm appearing for the respondent number 2, Lordship.
Why you have not filed reply?
Lordship, the matter was listed on the very last day of the vacation and after vacation, it is listed on the very first day, Lordship.
So
And Lordship, with regard to
during the
instruction,
course of vacation, you can very well file.
Lordship, we have received the instruction. The portal is 99% ready, Lordship. It will not
Portal
be-
is, my lord, ready, my lord. It may be released during this week, my lord.
Likhe.
Only with regard to
Lalit, you are appearing for?
My lord, I am appearing for the respondent number 1.
And you are appearing for 2.
two, Lordship.
What
And
about remaining respondent 3, 4 and 5?
High Court appeals, Lordship.
I am appearing for respondent number 5. One, and what about 3 and 4?
3 and 4 I represent, my lord.
You are appearing?
My lord.
Okay, Mr. So-and-so is appearing on behalf of the respondent number 1, 3 and 4. Mr. So-and-so is appearing on behalf of the respondent number 2. Mr. So-and-so is appearing on behalf of the respondent number 5. Service is therefore complete. And it consent for the respective counsels praised for and granted 4 weeks time to file. A reply to the petition time granted just after 4 weeks for admission.
My lord, if I may mention a small point, regards to the High Court, I had filed an RTI just to check if the system is working or not. With regards to the High Court Bar Association, the constitution, I asked for an online copy of the same. But the thing is, they have given me a confirmation email that the RTI has been filed, but it has been around a month, but the copy hasn't been forwarded to me via email or by the portal as such.
Take care of it.
Item number 8.
On the last occasion, the private respondent had sought time to file the counter malice.
I'm the respondent number 7, Lord.
Respondent number 1.
Number 1, who is appearing for that?
One MSJ Kalitamal, as per the order last occasion she had appeared. In fact, power has not been filed also.
Mr. J. Kalita, appearing on the so. Power has not been filed.
Because it appears from the last order, my lord. On the last occasion, it was not filed. She was supposed to file power.
And as well as the counter to the petition.
Post it after a week, my lord.
Who is Mr. J. Kalita?
I'm not aware, my lord.
Not a regular advocate?
I don't think so, my lord. I'll find out, my lord.
Just after 2 weeks.
Deeply.
Item number 9.
Wait, please, your lordship, my lord, IA 2464 was for substituted service. Thereafter, I have done the service, my lord. And affidavit was also filed. My lord, I think for IA 2288, my lord, so the delay was of 1,751 days. My lord, the judgment was passed on 18/8/2016. Against that which I preferred and writ appeal, it was dismissed with the liberty to give for a filing of a review. Then I filed a review. My lord, review was dismissed on 23/5/2023. Thereafter, I have challenged that order, my lord. My lord, I think, my lord, the respondents has appeared and I have to serve, my lord, they have to receive some copy of the IA of 2288. My lord, I will serve them copy today. Condonation. My lord, they say they don't have objection, my lord. From the date of review, my lord, there was no delay, but only because I filed a review because of section 14, if your lordship can consider that.
Department have department. School department have to believe it doesn't mean.
আছে কি বলিয়ে আছে inspector of states. Inspector of states. এই যে higher আছে, Johnson trade division equivalent. Higher আছে, higher আছে তো, class 9. Johnson trade division department higher than ওই দিয়া আছে। ওই দিয়া। He's coming back, he's on top of one.
So what's wrong in the judgment?
My lord, on affidavit filed by the Karbi Anglong, and my lord, on the advertisement and the affidavit, they have said the Reservation Act and rules which was to be followed was not taken into consideration. But they have affidavit, my lord,
The learned single judges
well, they have-
specifically refused to grant you relief that since 2009, these elections are.
my lord,
are
the
over,
last judgment
and now
also,
it is not open for them.
my lord, last judgment also, my lord, in the last judgment also, the single judge held the reservation was to be followed.
It may be.
When there was again a list, my lord,
After now, the selection took place in the year 2000.
my
We
only
are
thing,
not
my
going
lord,
to disturb
your
that
lordship,
selection.
on the day of admission of appeal, your lordship made.
There is no question of, we are hearing this application along on merits
No,
also.
then can it be on the next day, my lord? Because I was prepared on this, my lord. So
You just prepare your case. This substituted service, you have already.
I have done, my lord. I have to file an affidavit. Other side appeared. They have no objection as to your delay condemnation.
We have the objection regarding merits.
Well, yes,
They
I
may
understand.
not have the
I understand.
objection.
I understand. Taking into consideration the advertisement.
Okay. The matter comes upon for consideration of the IA number
2288.
2464 only 2023. In respect of substituted service upon the respondents. Full stop. Taking into consideration the affidavit filed on behalf of the applicant in IA number 2464 of 2023. The substituted service upon the unserved respondent be treated as complete. Full stop. IA number 2464 of 2023 is disposed of. Next में लिख देना. IA number. What is the IA number of that?
2288. 2288.
Yeah, next में लिख देना. Connected, writ appeal number 92 of 2024 is filed with a delay of 1,751
751 days.
days and application number 2888.
2288.
2288 is filed on behalf of the applicants with a prayer to condone the said delay. Full stop. Having gone through the taking into consideration the controversy involved in this, in writ appeal number 92/2024, we deem it appropriate to consider the IA number 2288/2023 along with the writ appeal number 92/2024. Delay is already condoned. Acha. So delay is already condoned.
Oh, delay is condoned. Then-
Delay is already
So
condoned.
it has not, it should have come for admission, man. Wrongly placed in there.
Then the delay in filing the writ appeal has already been condoned to hata dena baki sana. This writ appeal number 92/2024 for admission after 10 days. Be prepared for that.
I think in the meantime, we may find out how to reply.
Fine.
Item 10,
The order violated is, starts from page 36. Relevant is at page
36.
38.
What's the order?
Relevant is at page 38, madam.
Like the
Yes.
assistant teacher and the said appointment has now been cancelled. Fresh appointment is repeated order cannot be sustained. The same time, we do not find any case of 1925.
Relevant one, your lordship will get it at page 38.
So they have not paid this already.
They have not paid.
Notice.
Pending council, my lord, education, he was representing all the respondents.
But now
Now it is contempt,
now the contaminants are
has to be served.
added as respondent in their personal capacity.
Yes, understood.
Issue notice to the respondents returnable 4 weeks registered AD Dasti.
My lord, unless exempted as per rules, they have to appear personally. The rule says, my lord,
Let them come.
item 11,
stand by registered person.
Registered post plus Dasti, both. Respondent number 1.
Yes, ma'am.
Service has not been affected.
Yes, ma'am, in respondent number 1.
Okay, notice of IA number so and so has not been served upon the respondent number 1 since long. Let fresh notice be issued to the respondent number 1, registered AD Dasti, registered AD only.
item 12,
Here, notice has been served, madam.
Yes.
Taken to Monam.
As per the office report, notice upon the respondent number 1 is duly served. Full stop. None is appearing on behalf of the respondent number 1. The IA is preferred on behalf of the state with a prayer to
Condonation of delay, madam.
condone the delay of 173
73
days in filing the connected appeal. Full stop. Having heard the learned counsel for the applicant and after going through the contents of the application, we deem it appropriate to condone, to allow the IA number 976/2024 and condone the delay of 123 days in filing the present appeal. Hence, the IA is allowed. The delay of 173 days condoned, unless the registry is directed to registered the connected appeal and listed before this court after 2 weeks for admission.
Oblige Lordship.
Item 13.
My lord, there is a connected case along with this matter, my lord. I pray, my lord, this matter may come up with IA civil number 1046. It arises from the same.
It is
judgment, my
for
lord.
this IA is for
This
what?
is for leave application, my lord. They have filed an objection to the leave application.
So which is the connected matter?
IA, this is IA 1047. The other one is IA 1046 of 24, my lord.
That is also for the seeking leave.
Same judgment.
List along with IA number 1046/2024 after 2 weeks.
Item 14.
May it please your lordships, my lord, this is an application praying for condonation of delay of 265 days on the date of filing the accompanying writ appeal, directed against the judgment and order dated 14/6/23, passed by this honorable court in the writ petition filed by the private respondents against his termination order dated 1/12/22, passed by the applicant number 3, that is the headmaster of the school, herein from his services in the Assam Valley
Reason
School.
for delay?
Well, the reason for delay is, well, the petitioner, the respondent was to, in accordance with the rules, was to file when he files a representation to the governing body, he has to route it through the headmaster. What he does, he sends it to Calcutta. Well, the governing body is a group, well, the school itself is a private school set up by a group of private individuals, Malad.
So the learned single judge has decided the writ petition in absence of the school.
Yes, my lord. No notices were also sent at the first day
That
itself.
order?
The order appears at page 150 to 152 of the accompanying writ appeal, my lord. And the
order is dated?
Order is dated 14/6/23, my lord. Lordships.
The school was added as respondent number?
School in the writ petition was respondent number, writ appeal.
Respondent number 3.
Respondent number 3 here in this.
In the writ petition, respondent number 3.
3 is the headmaster.
Williams Bezer, Educational Trust 4 Mango Lane. And the respondent number 4 is the governing body of Assam Valley School.
Yes, my lord. Respondent number 4 is the governing body of the Assam Valley School. And respondent number 3 is the trust. And the headmaster is respondent number 5.
This is directing the governing body to consider the disposal of the appeal in accordance within a period of 2 months. So the direction is only to dispose of the appeal.
Yes, my lord, only thing.
Why? How you are agreeing?
Indeed, my lord. Only thing, my lord. As long as it doesn't become a right in rem.
What do you mean by right in rem?
Every other person who gets terminated from the services of the school.
And he has preferred an appeal. That appeal is pending.
Yes.
The learned single judge is only directed to dispose of that appeal within time frame. What's wrong in that, madam?
Indeed, my lord, but only thing as long as it is not a right in rem. Every person getting terminated.
This type of order even can be passed ex parte also. Always we are passing the orders. Then decide that representation, it's a innocuous, in fact, relief and nothing else. You are required to hear the appeal and decide it. Whatever it may be, the learned single judge has not given any direction that decide it in that way or this way. This is the only direction.
But only thing, my lord, if I may dare to say, my lord,
now
if I may
you are-
dare to say whether at all a writ
the
would
school
lie.
is stretching too far. It's only a direction to
Indeed,
decide.
my lord. Whether at all a writ would lie, my lord. That, of course, that is the only.
And still you have not decided that appeal?
My lord, that will be decided, my lord. He has not received it, but now he will decide it, my lord.
Decided. That's what we are disposing of. There is no direction in place. They have simply said respondent number 4 may decide the appeal. That appeal was filed on the 3rd of April 2023. They are supposed to decide, and within 2 months Again, the
Well,
2
only
months
thing-
time was granted.
He has filed a contempt application. That is the reason, my lord. The chairman of the,
Dispose it off. Don't do that.
very well,
Well, dispose it off.
Right.
Yeah.
deeply
The matter comes upon for consideration of the application number, IA number so and so with a prayer to condone the delay of 265 days in filing the connected appeal. Full stop. It is noticed that the learned single judge has disposed of the writ petition number 3097/2023 preferred on behalf of the non-applicant number
the
four.
Respondent number
Non-applicant number four. Number two, non-applicant number two, Monjit Roy. Yes. Non-applicant number two. Simply issuing a direction to the governing body of the Assam Valley School / respondent number four in the writ petition to consider and dispose of the appeal preferred by the respondent and non-applicant number two in accordance with law within a period of 2 months from the date of receipt of copy of the order. Full stop. Having noticed that, we are of the view that since the direction is only since the learned single judge has only directed the respondent number four in the writ petition to dispose of the appeal filed on behalf of the non-applicant number two. No case for interference is made out. Hence, the application for condonation of delay as well as the connected as well as the writ appeal number 4225/2024 in the bracket में कर देना filing number are disposed of. The applicants herein are granted a month's time to dispose of the appeal referred on behalf of the non-applicant number two from today.
my lord, and the contempt application, my lord.
And then application, you show this order to the.
Yes, my lord, I will do. Deeply obliged.
Item 15.
Lordship, I is for condemnation of 4 days delay. As per office note, Lordship, notice was served on the,
On Pushpa.
yes, Lordship,
Who is that Pushpa?
probably wife of the petitioner, Lordship.
How can, how we can ascertain that?
And the Lordship, taking report is also.
Wife of the, this sole respondent, how to ascertain that?
That, that is.
Flash notice. Okay. Pushpa received in the report. Postal.
Taking report is also annexed with the office note.
Pushpa. Addressee. Either you submit the proof that this Pushpa is wife of Paramjit, Shrimati Paramjit.
No, Lordship, probably some relative. Lordship, I will take fresh step here.
Okay. As per the office report, the notice upon the sole respondent has not been served upon her personally. Full stop. Learned counsel for the applicant is directed to take steps for issuing fresh notice upon the sole respondent through registered AD within a period of 1 week on taking such steps like notice be issued to the sole respondent returnable 6 weeks thereafter.
For admission, item 17.
Lordship, herein, your lordship, I have not served the copy
Copy of,
appeal, your lordship.
So, my lord, I'll serve, my lord. One thing, my lord, I want to strike down the name of respondent number 8 and 9.
8 and 9.
Yes, my
Why?
because, my lord, the school in question is not in existence.
Then what relief now you are seeking if the school is not at all in existence?
My lord, what happened, the school merged with another school.
Another school.
And in the IA also, my lord, your lordship allowed me to strike down.
You moved an IA for that.
My lord, IA is already over, my lord.
That I was for continuation of delay.
That has been allowed, my lord.
That has been allowed. And no IA for deleting the name of the respondent number 8 and 9?
That was allowed, my lord.
That was also allowed.
No.
8 and 9 was
I
allowed.
think
When?
My lord, that order was passed, my lord.
But still you have not filed any amended cost titles?
Yes, my lord, I have.
It is not on record.
It ordered that 3/6/24. First time correction of this is there. 24/4/2024. Lord, IA number 3846.
So there was no order for filing this amended cost title.
Yes, my lord, that is there, my lord. The order dated
So have you
24/4/2020.
filed any amended cost title or not?
Yes, my lord,
But it
We
is
have.
not on record.
we have, my lord.
School management committee, this
Ah,
Kuru Shakti MEM
yes,
represented
my lord. Yes, my lord,
and Abu Salah.
my lord.
There. You supply me copy. You are appealing on behalf of
One.
one.
Lord, I served the copy, my lord, that respondent 8 and 9 may be struck down one.
Sir, that has already been ordered,
In IA, my lord, not in appeal.
not in appeal.
Not in appeal, my lord. Appeal is first time for before your lordship.
You have not moved any application for deleting the name of the respondent number 8 and 9 in this appeal? Any application is moved?
No, my lord, here,
IA, certainly, IA, you have moved an application. Here, you no application.
orally I submit, my lord. Orally submit, not application.
Orally submit.
Yes, ma'am. Your lordship would be pleased to see order dated 24/4/2024.
Okay, learned concept of the
IA Civil 3846 of 2023, ma'am. Order dated 24/4/2024.
at the oral request of the learned counsel for the appellant, the name of the respondent number 8 and 9 are struck off from the array of the respondent at the risk of the appellant. Amended cost title be filed within a period of 1 week. In the meantime, the counsel for the appellant may supply the copy of the writ appeal along with the requisite documents to the counsel appearing for the respondent number 1. The respondent number 1. List after-
Lord, my lord, I have another prayer, my lord. Your lordship would be pleased to see the synopsis, my lord, of my writ appeal.
Yeah,
Here, my lord, it is wrongly typed as a writ petition. It should be writ appeal, my lord.
yeah, we'll
And
consider.
another one, my lord, index, my lord.
These are, we will consider it.
My lord.
We'll ignore this.
My lord,
We'll ignore this. Just after 2 weeks.
oblige.
Item 18.
Lordship, the OA was preferred against the cancellation of the recruitment process through a limited departmental examination. And in respect of Gramin Dak Sevak to postal assistant lordship, your lordship has passed this order. And this is in respect of Gramin Dak Sevak to postman. This OA has been reflected in the impugned order of the tribunal lordship. OA 255.
This recruitment process, the name of this recruitment process is?
Lordship, this is in respect of Gramin Dak Sevak to postman oblique mail guard.
This LDCE 2019 in that order.
This is also a LDC. That lordship will find
LDCE 2019.
notification is page lordship 20.
The same order कर देना, connect along with it. The same order. Connect last में कर देना, connect with the writ petition number 2475/2024.
Item 19.
Lordship 19 also, lordship, there is a lordship order, lordship is
That 30 to 50%.
50% from the date of last 3 years prior to the filing of the OA. Your lordship has state up to that extent.
Shall be paid from 3 years prior to the filing of the OA
OA,
number.
lordship,
What's the OA number?
lordship. OA number is 60 of 2019.
60.
60, lordship.
Armed Forces Tribunal.
Armed Forces Tribunal, lordship.
And the impugned direction of payment of arrears to the respondent.
It was directed from 2006, lordship is restricted.
17/2000 here in this order 17/1999 and there
1/11/2006.
1/11/2006. Same order. Connect with इसमें भी साथ में.
Oblige you.
Item 20.
May I please, Lordship? Lord, this is the writ petition against the order passed by the learned tribunal. Lordship, I prepared a synopsis. Lordship, in this case, what happened, the learned tribunal directed to refix the seniority of the petitioner at the stage of commissioner. Lordship, in 1991, there was the seniority of the petitioner, respondent number one was degraded from 91 to 95 on the basis of judgment passed by the Madras High Court, which was subsequently affirmed by the Honorable Supreme Court, Lordship. And this aspect of the matter was not considered by the tribunal. Tribunal says that the petitioner was not a party to the case in before that Madras High Court. Lordship, please to see the judgment.
Para number 7 of the judgment.
Yes, Lordship.
You just go to the para number 7 of the judgment.
Yes, Lordship.
This impugned judgment.
Lordship. Page 342.
Yeah.
Had the learned counsel both the sides examine the document on record and peruse the relevant Supreme Court judgment. The applicant was appointed as examiner on 15/6/1997 as per rules and then promoted to the grade of custom appraiser Group B on regular basis on 21/3/1991. As evident from the above, he was regularized on 21/3/1991 when respondent number 5, Sri Ananta Krishnan, who has been placed above him in the seniority list dated 11/2/2022, was not even born in the service. Sri P. Ananta Krishnan was appointed as custom appraiser on 3/5/1991. That is after a period of almost 1.5 months. The respondent department revenue have constantly taken the plea that the regular DPC could not be held and the ad hoc promotion in the department were carried out for the many years. For this fault of the department, the revenue, the applicant cannot be held responsible for, and he should be therefore not be prejudiced and denied his regular rightful position in the seniority list and deserve to be promoted to the post of commissioner. Moreover, the judgment of the Madras High Court dated 21/4/2006 cannot be applied in the instant case since the applicant was not made party in this case. It is therefore clear as broad daylight that the applicant's case is fairly and squarely covered by the judgment of the Honorable
So
Appeals
your
Court.
case was that he was granted ad hoc promotion and therefore his seniority can only be taken into consideration from the date when he was regularly promoted on that.
No,
This is what their case.
No, Lordship, our case is that in as per the judgment of the Madras High Court, his seniority was pushed back from 91 to 95. That although it was submitted before the court, Lordship, may please to see. Please.
The person, if the person was granted ad hoc promotion and thereafter he was granted regular promotion, the promotion will relate back to the date when he was granted ad hoc promotion.
No, Lordship, probably the tribunal has although mentioned in the judgment, but while passing the judgment, Lordship, this aspect, and Lordship tribunal has said that he was not a party to the Madras High Court judgment.
Yes.
Lordship, may please to see page 50, paragraph 50, clause D of Madras High Court judgment, Lordship.
Yeah. Page.
Lordship, I'm placing that. Lordship, paragraph 50 at page 31. Clause D.
Yeah.
There is nothing in 1998 rules to indicate that the seniority has to fix on the
Page
basis of principle.
31.
Page 31, Lordship, below it is mentioned. Paragraph 50. 50 subclause D.
Yes.
There is nothing in rule 1988 rules to indicate that seniority has to be fixed on the basis of principle of rotation. Therefore, to the extent a particular appointment is within the quota embarked in 1988 rules, seniority has to be counted from the date of substantive appointment, and there has been any appointment in excess to the quota for a particular year for a particular category. Obviously, such persons must push back and should be adjusted against quota of the category concerned during the subsequent year. And on the basis of this judgment, Lordship, the entire seniority in custom appraiser was revised and 171 officers were pushed back. And Lordship, subsequently, this judgment was affirmed by the Honorable Supreme Court. And subsequently also, Lordship, may please to see,
Notice. Returnable.
Lordship, may subsequently, this judgment was again affirmed and direction was given to the
Let us see, let the notices come.
Lordship. In the meantime,
Let the party,
Lordship, because Lordship, it will,
you get the notices out at the earliest, without hearing and
Lordship, please to consider this order also.
consider it, certainly, we are issuing notices.
Lordship, I'm praying for increased
Say,
stay.
no, not at this stage. Issue notice to the respondents. Returnable.
Then repeat may kindly be admitted, Lordship.
Admitted will hear them, and then if it is required admission or if it's
If the respondent
can
number
be
of-
decided at admission stage itself.
And in the meantime, the respondent has been transferred to Karnataka, Lordship. We may be allowed to sort through the still, Lordship.
The registered AD through as well as the state. Returnable 6 weeks. Item you are referring for?
UPSC, Performa respondent.
There are 13 respondents.
The Lordship, other are private respondent, they were also not heard when the order was passed. And the seniority was also affected.
Notice, Mr. So-and-so accept notice on behalf of the respondent number 2. Let notices be issued to the other respondents. To
Okay.
registered AD, returnable, the registered AD and Dusty, returnable 6 weeks.
Lordship.
Item 22.
May it please. Your Lordship, I am aggrieved by the impugned order at page 47 to 49 of my appeal. Actually, the petitioner's daughter has been detained wrongly by the respondent number 2 as the rules of the prospectus.
Dragging the minor daughter in this litigation.
Your Lordship,
She has not performed well. Do the counseling and ask her to appear in the next year examination. Why you are dragging her in?
not dragging her, Your Lordship.
You are dragging her and nothing else.
Your Lordship, the
What is the
rules-
authority of the court to give a direction to, even though if she has not secured the pass marks, to promote her to the next class?
No, the promotion is not as per the rules of prospectus. That is why I am before Your Lordship.
We are not. Better to give her, don't encourage such type of things. Don't encourage.
I leave it to Your Lordship because the rules of promotion says so.
The rules of promotion what? If she has not secured the pass marks,
No, your lordship, the rule 41A, I'm supplying. Your lordship, the rule 41A says that promotion depends on the student's performance throughout the year and not merely on marks scored in the final examination.
B2, B1, E, C2, E.
Yes,
Don't encourage this thing.
I'll leave it to your lordship.
Yeah. The, the present writ appeal is filed by the appellant being agreed with the order dated 17/5/2024 passed by the learned single judge in writ petition number 2575/2024, whereby the writ petition filed by the appellant has been dismissed. Stop. The appellant has approached the writ court being agreed with the action of the respondent school of not promoting his daughter to the next class, who appeared in class 11th examination. Class 11 उसमें करते ना Roman में class 11 examination in humanities section. Learned single judge has held that the High Court under Article 226 of the Constitution of India would issue prerogative writs in extraordinary circumstances. It is further observed that the decision to detain a student on failing in two subjects is that of the school, and unless an exceptional case is made out, this court would not entertain such a petition. Would stop. The learned single judge has not found any exceptional case and therefore has refused to interfere in the matter. Having heard the learned counsel for the appellant and after going through the material available on record, we don't find any illegality in the impugned order passed by the learned single judge. Hence, the writ appeal is dismissed.
Item 23.
It's regarding the section 435 of the Companies
Madam,
Act.
why the High Court should upload this notification in its website? It's not the High Court notification. It's the notification of the government, and the government has already published in the Gazette. Why the High Court should
There's
publish
a-
this?
It's also published in the High Court website as well, my lord. The previous one had the corrected form.
Where is the mandate of having it on the High Court website? There are many provisions under various laws that this case would be listed, would be heard by so and so magistrate. And every notification or every, the High Court is not
I have
displaying
about
that on its website.
It is about correction of the notification itself.
The notification itself was published in the Extraordinary Gazette.
It was, but it was, there is an omission in it.
What's omission? What
The
omission?
omission is that the sessions judge, a single sessions judge, that is 2A. So 435 2A is omitted, my lord. And hence, I have 3 matters pending related to company fraud, bank fraud, in the CGM's court.
Yeah.
And thereafter, I was not able to produce the corrected one there. And thereafter, a stay was obtained here in an criminal petition. And that has been languishing for the last 7-8 months now. And I am greatly prejudiced, my lord. And the previous one was actually correctly given, and the notification was correct, and it was uploaded in the High Court website.
Madam, this, please read your prayer.
Yes.
Writ of mandamus shall not be issued directing and commanding the respondent authorities to correct the error of omission to upload the rectified notification in the official website of the Honorable High Court. What is the mandate that the High Court should
It is
have this notification published in official website?
the official website notification has an omission, an error of omission, my lord. This part, the Sessions Court part is not given. Hence, it is not uploaded in the High Court one. The previous one is uploaded.
Maybe
So-
the previous,
so all
where is
my
the mandate of the law that
Actually, prayer is
any
very limited.
notification of the central government is required to be displayed on the official website of the High Court? Where is
But-
the,
Rectified, my lord. The notification itself needs to be rectified to remove the error of omission.
where is which notification is displayed at present?
The
At present-
notification at present is displayed at the previous one.
Where is that?
I didn't annex it, my lord.
You should have annexed it.
I should have annexed it, but now that I realize that I should have annexed it, but the previous one,
Should have annexed it, otherwise how could we realize that this, despite this amendment or
Yes.
whatever the notification, latest notification, there is no correction, should have amended.
I should have, but
You
because
should
it
have
is
placed it
already in
on
the
record.
website, because it is already in the website, I didn't annex it, my lord.
You just place it on record, we'll consider it. And why you are not, yes, Mr., you are for the High Court,
I'll file it with an additional affidavit.
you are for the High Court.
I'll take it.
So if the earlier notification is already displayed on the website and there is some change or new notification has come, why you're not displaying that on there? Do you have the copy of this writ petition?
Yes.
Copy of writ petition is
Yes,
supplied.
madam. I have.
Mr. So and so appearing for the respondent,
Number 2, madam.
respondent number 2 says time to complete his instructions. List on Monday. Next Monday, complete your instructions. Why you not displayed that corrected notice?
But unless the notification is corrected, my lord, how can it be displayed?
So only they have asked her to complete the
Monday,
instructions.
Monday, Monday, obliged.
Item 24.
It's my way, but still the order of the Honorable Single Judge. Lordship has already stayed a portion of this order, my lord. Now, it appears from like costly is a private respondent entered their appearance.
Respondent number 6.
Yes, sir.
Yes.
I am paying for it, sir.
Basically, my lord, the repetition is allowed on the ground that the respondent number 6 is senior to me, my lord. In the service, because it's regarding the provincial service under section 3111, my lord. There are more than one language teacher, amongst whom whose service should be permanent. What should be the criteria? I was provincialized. He challenged that he is senior, his service should be provincial.
So you can, why don't you apply to this under section 14?
They approached, my lord. The private respondent number 6 approached before the Honorable Single Judge.
And single judge,
I have the respondent there.
you are the respondent, then why
Yes.
you have filed this appeal?
My lord, because of the direction passed in this by the my lord, the land is single, page 44, lordship mechanism.
The decision of appellant authority provenance shall not be given effect to
Yes, my
final
lord.
disposal of the appeal.
So by virtue of that, my salary, everything was stopped. I was not get.
Yes,
Now, my lord, only the one thing is that, my
how
lord,
this direction can be issued?
So I
It is for the tribunal to grant stay when the court has not entertained whatever you have filed. How this direction can be issued?
I have assailed the provincialization order of the appellate law.
Sure.
And since there is a statutory provisional notice for appeal
under section.
The learned
14.
single judge has relegated you
And
to the
accordingly,
appeal.
I preferred appeal.
In between, how this, his provincialization can be stayed?
That was.
It is for the tribunal to consider, and if the tribunal has the
No,
power
while
to stay
the
that.
petition was filed, in the interim, lordship, the provincial order was stayed.
Whatever it may be,
But
once the
it is-
court has declined to entertain your petition on the ground of availability of alternate remedy, why this stay regarding provincialization of the private respondent?
That's true, lordship, but now the appeal is now pending before the authority. Now authority has to take a decision, lordship. Now, once the authority.
Will set aside this in the direction of and direct the appellate author, the appellate author to decide the appeal within a period of
Already that appeal is pending before the authority, lordship.
consider. Yeah.
So within a time from that appeal may be disposed of, lordship.
Well, actually, this is a case under section 19 of the 2017, because provincialization order is already been made. It is for the tribunal to decide the matter. They should have filed the yes, before the tribunal, educational tribunal.
That's what the learned
Yes,
single
now
judge has
that
had.
is for the appellate authority, section 14. It is not an authority under section 14. It should be the authority under section 19, educational tribunal, my lord. High Court has no jurisdiction to entertain in view of section 19 of this 2017 Act, my lord.
Lordship, this section 14 says if somebody is aggrieved by the recommendation of the district scrutiny committee as well as the state level.
Whatever it may be, whether that appeal
My
is
view,
maintainable or not,
provincialized
that is for the tribunal to decide.
Provincial, tribunal is under section 19, not
Whatever
under
it may
14.
be, if he has filed a wrong appeal, the tribunal will take care of that.
Tribunal
Allow-
should decide it.
Sorry, 19 no, no, no.
I'm not section 19.
The tribunal is having power to stay the provincialization or not? The tribunal has the power to. Then
Only thing that happened is prior to provincialization, it is section 14, it goes before the appellate authority in the department. Under section 19, it goes before the tribunal. Learned single judge is directed it to go before the appellate authority. Should have gone before the tribunal.
Yes. And he has filed the,
Before the appellate authority, not.
whatever it may be, it is not maintainable, not maintainable. That is for the tribunal appellate authority to decide. You know,
Section 14 is specifically said, no.
whatever it may be, okay. This writ petition is filed by the appellant, being agreed with the order dated 1/2/2023 passed by the learned single judge in writ petition number 397/2021. Full stop. The respondent, you are respondent number 6 here?
Yes, Lord.
The respondent number 6 herein has approached the writ court, being agreed with the provincialization of the appellant as a language teacher in the Bagri Bari ME Madarsa. Full stop. The respondent number 6 has claimed before the learned single judge that the provincialization of the respondent number 6 as language teacher is illegal, and the respondent number 6 was supposed to be, and the services of the respondent number 6 was supposed to be, were supposed to be provincialized as a language teacher looking to his seniority. The learned single judge has refused to grant any relief to the respondent number 6, but has relegated the petitioner to approach the appellate authority in view of the section 14 of the Act of, in view of the section 14 of the Assam Education in bracket provincialization of service of teachers and reorganization of educational institutes bracket close Act 2017. Full stop. While issuing such a direction, the learned single judge has further ordered that till a decision is taken by the appellate authority, the effect of the provincialization of the appellant shall not be given. Full stop. The learned single judge, the learned counsel for the appellant has submitted that the said direction of the learned single judge of not giving effect to the provincialization of the appellant is illegal and contrary to law. It is submitted that once the learned single judge has refused to entertain the writ petition filed on behalf of the respondent number 6 and has relegated him to the appellate authority, the direction of not giving effect to the provincialization of the appellant was not warranted. Full stop. It is therefore prayed that the said direction issued by the learned single judge may kindly be set aside. Per contra, learned counsel appearing for the respondent number 6 has supported having heard the learned counsel for the parties and after going through the material available on record, this court is of the view that once the learned single judge has refused to entertain, has refused to grant any relief to the respondent number 6 in the writ petition filed by him and relegated him to the appellate authority under the Act of 2017, the further direction of not giving effect to the provincialization of the appellant was not at all warranted. Full stop. In such circumstances, the direction given by the learned single judge of not giving effect to the provincialization of the appellant is set aside. It is informed that the respondent number 6 has already approached the appellate authority as per the liberty given by the learned single judge, and the appeal filed by the respondent number 6 is pending consideration. In such circumstances, it is directed that the appellate authority shall consider and decide the appeal filed on behalf of the respondent number 6 within a period of 2 months from the date of production of certified copy of this order. With these observations, this writ appeal is disposed of.
But only after giving an opportunity also to hear.
After providing opportunity of
Yes, ma'am.
hearing to all the concerned.
Yes, my. Did applied.
Item 27.
May I please proceed? The response of the opposite party noted 32 OPSR.
Yes.
27.
This was listed before the division special bench, my lord, where the rules were being changed.
They segregated it from the
My lord.
munch matter, yes.
So we'll have to file our affidavit in this matter.
Nikhil and counsel appearing for the so and so. Place for and granted time to file counter to the petition list after 6 weeks.
Item 29.
Please, your lordship. Lordship, this was against the order of the learned single judge, wherein it was, the order which was impugned there was that our names were nominated as president and vice president of an SMDC of a higher secondary school.
Not, your names were not forwarded while
As per
following the
notification.
due process of.
By due process, that was the thing. And our primary ground was that at that time, due process definitely could not be followed because headmaster was not there, principal was, headmaster was not available, and the IS was holding the charge of the headmaster.
What happened, that, whether this exercise has been completed or not?
Till now, it has, that department can.
This order is dated 25/4/2024, and within 3 months, you were supposed to complete the exercise. What happened in that?
Maybe on Wednesday, I'll have my.
Tuesday, next Tuesday.
Next Tuesday.
Confirm, take your instructions.
Item 30.
Yeah. In the case, actually notice was issued. And they were directed to produce the record, and notice was also issued in the interim period. And which he was granted. The matter relates to the tender in the railways. My lord, can look into the last order, on 2/7/2024.
Yes.
Lordship, his tender was rejected on the ground on technical bid, Lordship, because he has not submitted the annual turnover certificate, Lordship, and he submitted an annual turnover certificate, but it is of proprietorship firm. And this is a partnership, his Lordship participated as partnership firm. And he has not submitted any documents, Lordship, relating to the relation between this proprietorship firm and the partnership firm. And on this ground, Lordship, in technical bid itself, his bid was rejected.
So what, this, have you submitted the record?
Lordship.
Where is the record?
In page 746 and 732, Lordship, the tender committee evaluation is here, 746 and 732. Tender process is already completed, Lordship.
Nineteen ninety-eight. New original limited. This. If it says only this. This para one of the GM and para three of the terms and conditions, what are they? Where are those?
Your lordship will find it page.
Page 52 of the redaction.
Page 52.
52.
Yes.
This is the bad one.
52, the minimum average annual financial turnover of the bidders during the last 3 years ending 31st March of previous financial year should be as indicated in the bid documentary evidence in the form of certified edited balance sheet of the relevant period or a certificate from chartered accountant. Cost accountant indicating the turnover details of the relevant period shall be uploaded with the bid. And my lord,
And secondly, Lordship, in case of constitution of the Lordship,
Date of
Incorporation
constitution
less than 3
incorporation
years.
of the less than 3 years old. Average turnover in respect of the completed financial year after date of shall be taken into a criteria.
An appellant firm was constituted only on November 23, Lordship. It has not even completed 1 year of one financial year, Lordship.
This proprietary partnership firm.
Yes, Lordship, partnership firm.
Lord, my lord, the father was the proprietor, my lord. My lord, when he was alive, my lord, the partnership was constituted on, my lord, in November 2023. But I have given the documents now. My lord, now father died on sir. Oh, they have. Oh, sorry. 58.
So who was the proprietor of that firm?
Father.
Father.
The my lord, in the partnership, my lord, the wife, now my lord, the wife, two sons. They are the partner, my lord. My lord, before the mother father died, my lord, the partnership was, my lord, constituted. With the father, two sons were there, who are also the partners now. Father died on 17th of January. Then, my lord, the farm was, my lord, reconstituted on 14th of, my lord, February. With the induction of the mother in place of the father. And my lord, they wanted only the turnover of the my lord, farming questions. So, my lord, since the my lord, it was a continuation of the my lord earlier farm. No change in the name, nothing else, my lord. Assam Supply Syndicate.
This partnership was constituted on which date?
My lord, your lordship will find.
Earlier it was a proprietorship firm.
Yes.
Then
1st of November 2023, my lord.
1st of November 2023.
23, my lord. May I just, my lord, refer to the document.
104.
One zero four.
Yes, sir. Ramotar Jalan, he was the father. He was alive at that point of time. Then Anurag Jalan and Chirag Jalan,
Yes.
these are the two sons. Now, my lord, the next page, 105 is important, my lord. Whereas the parties abandoned in the first part was a proprietor business and selling and supplying so and so and contracts at Sachibai, Guwahati in the district of Kamrup under the name and style of Mrs. Assam Supply Syndicate. His son, Anurag Jalan and Chirag Jalan were deeply engaged in the conduct of the business and have gained rich experience over the years in their association with Assam Supply Syndicate. And whereas the party here too, or the first part, keeping in mind the old age and the experience gained over by the by years by Anurag Jalan and so, desires to constitute a partnership with the party here too of the second and third part, which so and so and acquire the above mentioned proprietorship business fully as going concern under the same name and style of Assam Supply Syndicate. All these assets and liabilities, including liabilities on account of GST and all other rates and taxes pertaining to the erstwhile proprietorship form of the existing proprietorship concern, shall be taken over by the firm in totality from the date of acquisition. Then my lord, rest are not much important, but I'm not citing. Then my lord will kindly come to directly page 113, my lord. In the meantime, father died, my lord. I have given a copy of that also.
And this proprietorship firm was established in which day, in which year?
1984.
Huh? The industry department has issued a certificate of 1984.
1984. And later on, you created this partnership in the year 2023.
23 in November, my lord.
November.
November, then father died on 17 January, my lord.
2024.
24. Now, my
14th
lord,
of-
after the father died, my lord, the mother was inducted as a partner in place of the
14th of February.
14th of February.
So when they issued a notice to you to clarify this
No,
position,
they have not issued any notice, my lord. That is the difficulty, my lord. There is under the tender, there is a clause that there will be a my lord clarification required. For this clarification, 2 days time is there. They have not asked for, that is my contention in the my lord, writ petition as well, my lord, and before this honorable court also, that they have not sought for any clarification.
But
Then, my lord, after my
but
lord,
the
10th,
learned single judges considered this and said,
no,
you're
they have not, they said that these are additional document we cannot consider.
Yeah.
Your lordship will kindly come to that, my lord. Page 133.
para number.
My lord. 133, my lord. It's a document communicated to me on 14/6, my lord, at 7:18 p.m. The bidder has participated in the G bid with bid specific authorization from Havels, which is so and so and so. The original offer of the bidder has been deliberated on the basis of the GM bid document conditions and further submitted by them, and accordingly disqualification has been communicated to them. On the basis of the, my lord, the turnover, my lord, they said it was of the not partnership.
This on 10/6/2024, they rejected your bill.
True, my lord. Then, my lord,
And on 11/6,
My lord,
you
I
have submitted your
submitted-
clarification.
I submitted the clarification.
Where is that clarification?
My lord, your lordship will finally find that page page 103, my lord.
103.
Yes. 103 along with these documents, my lord.
Just a minute.
The second and third page. I will be able to-
What is the response to it?
Well, that 133, my lord.
133.
Yes, my lord. Their basic contention is that, my lord, since you have,
Just.
I'm sorry. clarification के लिए भेज दिया था। Statement consequence. Please move on, sir.
There is that condition of clarifying 2 days time is granted for clarification.
Well, not granted, I have made a specific statement in para 12 of my writ petition, my lord, at page 69.
Yeah.
Page 39.
No, you, page?
Page 39 of the writ appeal, where I have annexed. Para 12, my lord.
Yes.
My lord, the petitioner further stated at no point of time during the technical, the respondent authority sought for the clarification with regard to the certificate in respect to annual turnover. In this connection, it will not have out of place to mention that the perusal of the bid document would show that 2 days time is kept for technical clarification. During technical evaluation and the response
Yes, where
authority
is
could
that
have.
2 days time was provision of giving 2 days time?
Not
Bid document, you look at the perusal of the bid document, it will show that 2 days time is kept.
I'll show the bid document.
Page 15.
Page 50. Page 50. 50. Page 50. Last row.
50, yeah. Time allowed for technical
2 days.
clarification during technical. Madam, whether you have granted any time or sought any clarification from him?
Lordship, here it is stated about the clarification, Lordship. He has not even submitted the documents. It is not for clarification. His case is not for
Documents,
clarification. Lordship.
these documents which he has mentioned now, this partnership deed and this again substituted partnership deed, they have not submitted.
Not submitted, Lordship. These are submitted after he disqualified in the technical bid, Lordship.
But before finalizing the technical bid, whether you sought any clarification from him or not, from the firm or not?
So, Lordship, when the technical bid was considered, Lordship, and he had submitted the annual turnover certificate of proprietorship firm, in the absence of any annual turnover certificate of partnership firm, Lordship, his technical bid was rejected. And after rejection, Lordship, he has submitted all these documents. After opening of the bid, Lordship, technical bid, Lordship, he cannot submit all these documents. He was required to file before while he submitted the bid, Lordship. As per the bid document, page 50, Lordship. Page 50, Lordship, page 50. Here there is a provision, documents required from seller at column 13, Lordship. Document 50. Document required from seller. Here, Lordship. It is bidder turnover certificate request OEM author. It was specifically stated, Lordship. In case any bidder is seeking exemption from experience turnover certificate criteria, the supporting documents to prove his eligibility for exemption must be uploaded for evaluation by the buyer. So his case is also Lordship a kind of exemption because he has sought as a partnership firm, he has no turnover certificate. And therefore he has Lordship used the proprietorship firm turnover certificate. And in that case, he was required to submit all these documents with the bid. As per this bid document, Lordship condition.
File your response. File your response. That's it.
Even without already, Lordship, process has already been completed. Only the issuance of work order is.
File your response in how many days you are going to file?
Plus today itself, I am filing my affidavit, Lordship.
Along with whatever documents you are relying on. Okay.
You can fix, Lordship, on Friday, Lordship. Friday, Lordship.
Make it even Monday, whether it's not.
Pursuant to the direction given by this court on 2/7/2024. Ms. R. Devi, learned CGC has furnished the record of the tender process. Full stop. In the tender process in question. Learned, we have perused the record. Learned counsel, Ms. R. Devi, is granted time to file counter to the writ appeal by the next date of hearing, put upon Monday. 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 Upon Monday.
22nd. Malad, in the meantime, the interim order is still today.
Interim order.
Lordship, interim order was granted on the ground that he has quoted less amount than the other. No, this fact, Lordship, he cannot be considered because financial bid, he has not come to the financial bid. His technical bid was.
Oh, that's right. That's right. You submit your bid, the petition will tell you. Interim order passed with this court on. 2/7.
2nd of July.
2nd of July 2024 shall remain in currency till next date of hearing.
I'm obliged.
Record of the tender process in question be produced on the next day also.
Or they may submit the affidavit early so that I can file a reply to that.
Lordship, today itself I am filing, Lordship.
Much
ready.
okay.
Item 31.
Please, Your Lordship. Well, in this case, the reply is yet to be filed by the other side. I'm told they are preparing the reply in this matter.
In this case, Mr. Gupta is appears to Lordship fixed next week or then Lordship.
Mr. H.C. Gupta, H. Gupta.
Yes, Lordship.
2 weeks.
Lordship.
Item 32 and 33.
Yes, who is for the state?
Just now, Mr. Gogoi informed me that he has not received the instruction.
Many dates have gone.
But the matter relates to.
The recommendation is already there.
Yes. My lord, finance department is delaying simply, my lord, on some untenable grounds. They're trying to.
Earlier the election and now I don't know what happened.
In fact, on last occasion, Lordship asked him to up the instruction also.
Yes.
My instruction is every, can it be after 10 days only?
So we'll ask the finance secretary, he'll give the instructions.
No, no, you
He'll remain
come.
present before this court on the next interview.
Let it be on Monday in that case, madam. On Monday.
Should have 3/6/2024.
I understand, madam. On
1.5
Monday.
month almost.
The last half, madam, on Monday.
Mr. Gogoi, then it's standing consent for the finance department place for and granted last opportunity
Lordship.
to complete his instruction regarding the cabinet decision dated 15/3/2024, whereby the government of Assam has decided to follow one pay for same and similar work policy.
22nd, madam.
Next Wednesday.
Item 34.
Made to the last. My lord, I also filed an affidavit on 23/4/24, my lord, explaining the circumstances under which that document came to be annexed to the additional affidavit filed on 23/9, I suppose. On 12/9, my lord. If lordship would kindly come to page number 178. Para 4 onwards. May I read it, my lord? Page 178.
Yes.
That after coming to know about the aforesaid decision of the APSC, the advocate for the deponent, Kobin Saikia, filed an applied application dated 28/8/23, applied before the Public Information Officer, APSC, seeking a copy of the minutes of the commission held on 18/5/22 under Right to Information Act. That despite the application dated 28/8/23, APSC did not furnish the required information, that is the minutes of the commission held on 18/5/22. That the writ petition that is so-and-so instituted by the deponent appellant, assailing the selection of respondent number 6 as principal of Pokrajar College, came to be dismissed by the learned single judge by judgment and order dated so-and-so. Having failed to agree, the deponent appellant instituted the present appeal on 21/7/23, which is presently pending for disposal. That the deponent appellant states that on 9/10/23 and 11/10/23, during the course of hearing of the present appeal, the counsel for the APSC so-and-so questioned the veracity of the minutes dated 18/5/22, which was brought on record by the deponent appellant by an additional affidavit on 12/9/23. Having regard to the submission of the counsel for the APSC, this honorable court by order dated 11/10/23 was pleased to direct the deponent appellant to complete the instruction in the matter, and was further pleased to observe that on the next date of hearing, honorable court would consider initiating appropriate proceeding under section 340 CLPC. That situated thus, the deponent appellant on 19/10/23 filed another application under Right to Information Act, seeking inter alia the following information: whether the minutes dated 18/5/22 annexed in additional affidavit in writ appeal having signature of the members of the APSC exist in the records of the APSC, whether purported minutes dated 18/5/22 produced by the counsel for the APSC before the honorable court was circulated in supersession of minutes dated 18/5/22 annexed in the additional affidavit, whether the minutes dated 18/5/22 annexed in the additional affidavit is a draft. After following the discussion, did the minutes dated 18/5/22 produced by the counsel for the APSC before the Honorable High Court took the shape of a final minute? That pursuant to the application dated 19/10/23, the State Public Information Officer, APSC by dated so-and-so, furnished the information, though not as sought for. That now it transpires, the APSC would have responded to the application dated 28/8/23 submitted by the deponent, appellant under the Right to Information Act, the present controversy could have been avoided.
So you have said that this one Rajesh Burman.
Yes, para 11 and
Was
12
applied and to
Yes.
Rajesh Burman, Dr. Niranjan Kalita.
is the member who signed the proceedings.
So it's very, in the absence of their affidavits here that they have supplied that, how you can be exonerated from that?
No, my lord, the question is, the issue is only one thing, my lord, whether it is 70% or 80%. Otherwise, everything is ditto.
Ultimately, your claim was that it was 70% or 80% or whatever it may be.
My lord, I have made one statement, if your lordship would kindly permit me to
Yes.
read that paragraph,
Yes,
para 13.
yes.
Kindly see that as per the information gathered by the deponent appellant, the submission made by the counsel for the APSC that the document annexed at page 174 is a non-existent document may not be correct. The appellant has reasons to believe that the cutoff mark of 70% is followed in interview other than combined competitive examination, while cutoff mark of 80% is followed in combined competitive examination. My lord, only for combined competitive is for the civil services of the state. There, according to our information, they follow these 80%, and for others, they follow 70%. APSC is entrusted with selection of so many other posts also, apart from the combined competitive civil examination. And there is no reply to this affidavit, by the way, my lord.
Where is that copy of that minutes of the meeting which you have submitted
Yes,
initially?
page 174, my lord. As part of the affidavit dated 12/9. Other than this word 70%, everything is same, my lord. The original copy is at 75 and typed copy is at page 174. The first subpara, the meeting opined that marking should be judicious after making a reasonable assessment of the candidate's personality and other attributes, and as such, it is considered to be appropriate if interview board members desire to give extremely high mark to any candidate, that is 70% and above, the board should record the reasons to justify the award of such high marks. The one they have produced, it is 80%. And they said in the document which they have annexed, there are 3 copies. And the one which we rely upon, it has got 4 copies.
From where you got this, that in the this combined competitive examination, they are following this and other they are not following this?
My lord, that was
From where?
also informed by the same source, my lord.
As per the information, the submission made to council, the document annex is a non-existing document, may not be correct. The deponent reasons to believe that the cutoff mark of 70 is followed in the interview other than the combined, and while
Yes.
cutoff marks, from where you got this? What is the clarification regarding that, sir?
As per the minutes of meeting of 18/5/2022, this is the original. It was
That you have already produced.
Yes, Lordship.
That you have already produced. Here that 70 and 80%, that is clear, not 70 and it is 80%. But what in para number 13 there, so unfortunately the APC, the document annex is non-existing, may not be correct. The deponent applied the reason to believe that the cutoff mark of 70 is followed in the interview other than the combined competitive, and while cutoff mark is followed in combined competitive examination. What is the clarification about this?
Lordship, there was a minus, Lordship.
Yeah.
There was a minus, Lordship, in that regard, Lordship.
There
was a minus, Lordship.
There are minutes.
There are minus for prescription of 80% in case of combined competitive examination, and also that 70% in respect of some direct recruitment, but not in this case, Lordship. Because, Lordship, I am just simply like to point out, Lordship, this is a case, Lordship, where this election was conducted under the Assam Education Service Rule, Lordship. Education Service Rule does not prescribe any procedure for prescription of mark, Lordship. Therefore, Lordship, we adopted the office memorandum of Government of Assam Higher Secondary Education Department. There is no prescription of cutoff mark of 70%, Lordship. So in this case, Lordship, that 70% or 80%, whatever may be, is not applicable. The 70% mark, Lordship, which was prescribed in as per the minute submitting, was in respect of other direct recruitment where there is no service to prescribe, Lordship, which should be conducted by the APSC own procedure, Lordship. And this case, Lordship, the submission made by my learned senior friend is not correct in that point of view. It is some misleading submission in that aspect.
Then you clarify this position.
Yes, I have clarified, Lordship.
You clarify this position.
There apart, Lordship, in paragraph 12, Lordship has pointed out, he has named 2 persons.
Yeah.
One is Dr. Rajesh Prasad and Niranjan Kalita.
Yeah.
That they are not supposed to know the internal communication of the APSC.
Niranjan Kalita was the member of the APSC.
Member of the APSC, and he was also the one of the member of the selection committee who awarded 80% mark to one candidate. What is the nexus, Lordship?
Whatever the source of information is, you will consider that.
My lord, there is one more.
If there is any requirement, we'll ask those 2 persons to verify this.
Yes. My lord, there is one more aspect, my lord. Just now, my learned friend has said that for direct recruitment, where there is the rule does not prescribe anything, then they apply. Hello, kindly see self-defeating argument which my learned friend is making.
You just clarify this paragraph.
No, there is one more thing, my lord.
I'll clarify.
Before that, my lord, my learned friend is saying so many things now. Please come to page 45 for a moment, my lord,
Yes.
of the writ petition appeal. Now, before that, your lordships will kindly come to page 43.
Yes.
43. This is the advertisement issued by APSC. This selection procedure will be notified later on, followed by issuing corrigendum, addendum if required. That means the procedure which they will follow in making the selection, they will notify.
Page 43.
Yes, my lord. It's part of the advertisement.
What is that, this selection procedure?
Page 43, my lord, on top. Memo of appeal.
Yeah. The selection procedure.
Selection procedure will be notified later on, followed by issuing corrigendum. Now, Mike, please come to page 44. This is the corrigendum they issue. In continuation of this office advertisement dated so and so, for recruitment to the post of principal, it is for the information of all concerned that Higher Education Department wide letter dated 9th of February 22 inform the commission to follow a government OM dated 25 to 19 regarding educational qualification for the said post. In view of the said letter, the educational qualification as mentioned under clause 4.2 of the earlier advertisement, research guidance is dispensed with for applying for the post of principal. Now, my lord, selection procedure they have not notified.
No, page 46 may kindly be seen.
No, please, no, please make your submissions when it comes. My lord, this circular 25 to 19 of the government of Assam, it only speaks about, it's nothing but, my lord, UGC regulation has been adopted. It only speaks about what all are the educational qualifications required. But how selection would be made, they said they will notify later on. Now let us read 46. Kindly read, let us read it, my lord. In continuation of this office notification dated so and so, it is for the information of all concerned that Assam Public Service Commission will hold interview for the post of principal as per the program given below at it so and so. No, this is only the program. What about the procedure? My lord, in this case, the difference between the selected candidate and the appellant is 0.07. And one member has given, my lord, 5 to me and 18 to a respondent number 6. That is why, my lord, I wanted to know what is the procedure they are following, whether they can give such high mark.
You
That is
clarify this. You clarify this and then we'll consider.
I'll clarify.
Then concept of bidding for the respondent number 2 is directed to is prayed for and granted time to file counter to the additional affidavit filed on behalf of the appellant on 23rd of April 2024, particularly clarifying the contentions made in para number 13 of the said affidavit. When?
After 4 weeks.
After?
4 weeks.
4 weeks?
2 weeks.
4 weeks is, you have to simply submit a clarification. List on 22nd July. 22nd.
22nd, I think.
Can it be 25th?
Yeah.
25th.
25th, बहुत case होगी, so no करेगा. Let it be 22nd, 25th, so many matter has been fixed. Let it be.
So 25th.
26th.
Okay.
26th July.
Supplementary list, item 43.
Yeah. My lord, in this case, our only grievance is In this case, our only grievance is, my lord, it was not properly valued, my lord. It was not valued. Now, Lordship will kindly see, my lord. Now, they have fixed the valuation at 74 lakhs. And we have got the valuation done, my lord, through some private source. And the value is 2.42 crore. We are only, no, my lord, let them satisfy that there is compliance of Rule 85.
Mr. Chaudhary, while exercising powers under Article 2226, we have no such power. And you can approach very well. You can approach.
No, my lord, I have approached the DRT.
You DLT, then if you are aggrieved by that, you can approach the further authority.
No, my lord, already sale notice has been notified. Everything is done. It will be too late.
Done, sir.
No, for a moment, Lordship will kindly read Rule 85. Thereafter, Lordship, I'll not make any argument.
Certainly.
Rule 85.
Yes, sir.
That's all. I also know the limitation, my lord.
Sir, now the Supreme Court has come very heavily.
No,
on
correct.
that. And latest, sir, in 2024 itself, they have deprecated this in so many words. बस वो जो कहते हैं गाली नहीं दिया बाकी everything they have done. We can't do that, sir.
Please come to sub-rule 5 of Rule 8, my lord.
Yes.
Before effecting sale of immovable property referred to in sub-rule 1 of Rule 9, the authorized officer shall obtain valuation of the property from an approved valuer and in consultation with the secured creditor, fix the reserve price of the and may so sell whole or any part of such immovable secured assets by any of the following method. Well, we are saying this was not done. That's why it is, my lord. Only no, my lord. It's a racket is going on.
You can very well raise this ground before the appellate forum, sir.
No,
This is the ground.
No, Lordship will.
They have to satisfy.
Then in that case, Lordship will give us some protection for 2 weeks. Will approach the appellate forum.
Absolutely, sir.
No, my lord, already sale has been. No, my lord, sale has been notified.
Sale certificate already been issued.
Sure, that's why I'm saying, my lord.
Sir, whatever. Sir,
No, it will be full. No, my lord, it's not a case where it is. I mean, where lordships cannot. I mean, handle the issue. My lord. I appreciate there are limitations. My lord will kindly see in Guwahati city, 1+ katha of land and a RCC building, 74 lakhs. My lord, the big racket is going on, my lord. These bank officials and these, there are purchasers are in hand in glove. This is happening in this country. That's why I'm saying, my lord. All that I'm asking for is a procedural safeguard provided in Rule 85. Let them satisfy lordships tomorrow that this was complied with. End of the matter.
Sir,
thereafter, lordship will.
April 10, 2024 order, 3 judges bench of Supreme Court.
I know.
It is our being clarified, will not entertain a petition, Article 2, if an effective alternate remedy is available to the aggrieved person or the statute under the complaint has been taken itself, contain a mechanism for redressal of grievances. Undisputedly, the pending case so and so, we are therefore considered with the High Court. While dismissing it, we have to remind the High Courts the following words of the Supreme Court, sir. They have reminded us, but मैंने जो कहा वो उतना ही नहीं किया, बाकी they have done everything. Yes.
No, all that I'm asking for is, my lord, some leeway so that I can approach the appellate forum.
Sir, that is also
They will not take coercive measure for 2 weeks or 10 days time.
Sir.
For 10 days, my lord.
Sir, extreme. And prior to them, there are so many there.
No, my lord will kindly see 1 katha plus land and a 2-story building. Can it be 74 lakhs, my lord?
Sir.
In Guwahati is a small place. As such, the value of the land is so high.
Will grant you only liberty if you.
Yes, we are seeking liberty.
Yeah, liberty. Okay, learn consent for the after attempting to argue the matter for quite some time, then consent for the petitioner. Some on instructions as submitted, he wants to withdraw this writ petition. However, seeks liberty for the petitioner to approach
the appropriate forum, my lord.
Section 19, I think so.
Section 19.
To approach
17 and 19.
Section 18.
17, so you have already.
Already availed.
Section 18.
18 and 19, my lord.
18 or 19.
18.
Appeal to the appellate tribunal. That
Section
is
18.
Appeal to appellate tribunal.
18.
18. To approach the appellate tribunal under section 18 of this Securitization Act 2002. Full stop. Liberty is the writ petition is dismissed as withdrawn with liberty to the petitioner to approach the appellate tribunal under section 17 of the Act of 2022 and to raise all the possible available grounds before it.
Deep level.
For hearing, item 35 to 37.
Here, issue is pending before the apex court, my lord. Issue is pending before the apex court. Last occasion also, my
Issue
lord.
is pending before the apex court.
Yes, my lord. Still pending. So after 2 months, maybe come, my lord.
Payment of interest.
Yes, my lord. Delay.
What's the, any next date?
No, no. After 2 months, my lord, that will come.
Then consent of the parties have submitted that the controversy involved in this petition is pending consideration before the Honorable Supreme Court. In such circumstances, this matter after 12 weeks.
But okay.
Item 38.
My lord, kindly pass over the matter for the time being. At 2.
Yeah, 2.
Lord, sure.
At 2.
Item 38.
Yeah, to vote. Not to vote. 6, 7. We go down to say. Yes. Pokoknya dia aduh apa tuh konsen itu saya bikin kali 7 ini lah bukan sih yang tuh dibanding dengan original itu bisa kan tuh yang nah itu sih itu mau tuh itu provision ada sih ya
But although the petition is voluminous, my lord, the sum and substance of the issue is, it's a.
All the typed copies. No document.
In fact, that is the contention, yes,
That is the main reason.
main reason. And so far as number of days is concerned, my lord, all the petitioners, before your lordships, they have completed 240 days.
That's the question, because you have failed to produce the evidence of this effect that you have completed 240 days and whatever the documents you have submitted in support of your claim. Those were the typed copies of a document, original of which was not produced. And they have specifically denied no such document is there.
My lord, subject to correction, my lord.
Yeah.
Not only the type copies, photocopies all were there. Now they wanted original, my lord. It will not be possible for a casual labor to produce original before the learned tribunal. And we produce the photocopy, that documents, those documents I have annexed.
Earlier in the year 2014, the tribunal has decided your claims. In 2014, the tribunal has decided your claims regarding regularization and granted some relief to you. But later on, the High Court has remanded that matter again to the tribunal. Where is that High Court judgment?
Yes, my lord. My lord, in 2014, the tribunal, my lord,
decided in your favor.
no, dismissed all the OAs.
No.
Yes, my lord. It was a
2014 dismissed all the ways.
common order.
Then the High Court has remanded the
Remanded back.
referring to section 20, subsection 320
Yes.
and 22, record the evidence and do all these things. And
Yes, yes.
thereafter, the tribunal has decided your claims.
Yes, thereafter, again, the matter was decided by the learned tribunal, and that was again challenged by BSNL before this honorable court. And again, the matter, I'll just, my lord, take your lordships with the various orders, my lord.
Yes, yes.
First, the first judgment of the learned tribunal, your lordship will find page 59, annexure P2.
Yes.
This was the first, my lord, amongst the first, my lord, because prior to this also there were litigations, my lord, before.
Maybe we start from this.
Yes, my lord. So finally,
Page 59.
page 59, annexure P2.
And
Now,
the final observation of the.
yes, my lord. Now here, my lord, I'd like to just point out one thing. My lord, here there were several original applications or transfer applications before the learned tribunal. The only point of exclusion of the present petitioners from those petitioners, other applicants before the learned tribunal, is that, my lord, the present petitioners before your lordships, my lord, they are still working. Since 1995, 1992, for last 28, 29 years, they are still working. But the other applicants before the learned tribunal, they were discontinued in the year 1998. Fine. So that is the, my lord, distinguishing factor. So this order operative portion, your lordship will find page 124.
We have also examined whether the orders passed by the verification requires any interference or therefore examine whether particular observation will be considered. In view of the discussion above, all the TAs and OAs are dismissed.
Dismissed, my lord.
Fine.
Thereafter, my lord, this honorable court's order, your lordship will find page 125.
Yeah.
One of the order has been annexed, my lord.
Yes.
Now, this honorable court, by virtue of this order dated 19/3/2013,
Fine.
operative portion, I'll just take your lordships. Page 139. Para 36, my lord, down.
On a bare reading.
On a bare reading of clause C of subsection 3 of section 22, it becomes clear that the Central Administrative Tribunal has the power to receive evidence on affidavit, and it has also the power to requisition any public record or document or any copy of such record or document from any office
Yes,
and
They have said, you take the evidence and decide.
Yes.
You have power to do so.
yes, my lord. So matter remanded back, then one division bench, my lord, heard this remanded back matter that you also will find page 141.
141, division
Yes.
bench of this, yes.
Central Administrative Tribunal.
Yes.
Now, the observation of the bench with regard to the present petitioners, your lordship will find page 151. 51. The name of the petitioners, your lordship will find page 149.
Okay, in this case, the learned concept of the applicant.
Yes, so-and-so has submitted that the applicant has completed 240 days. Mr. So-and-so, learned counsel for the respondents clarified that the applicants have completed 240 days, but not continuously. They were absent in their duties without any reason, and therefore they are not entitled for conferment of temporary status. As per the direction contained in the judgment of the Honorable Supreme Court and scheme so-and-so, they are entitled to the benefit mention of the scheme, including temporary status and subsequent regularization. The petitioners are eligible for grant of temporary status as mentioned in the scheme, but the respondents withheld the said benefit to them, whereas the said benefit has been extended to the other similarly situated employees, TA allowed. So all the TAs below individual orders were passed. So this order was again challenged by the BSNL before this Honorable Court.
What is that?
This was challenged. That order your lordship will find page 162, my lord.
162.
Yes.
162.
Lord, instead of filing so many cases, our temporary status could have been given, my lord. What we'll get? We'll get only group D pay scale. Yes, my lord. Page 162, the operative portion your lordship will find.
Page the para number 6.
Para 6, my lord.
The dispute in respect of the claim of
Yes, status of temporary Mazdoor subsists even as on date, as the matter is yet to be brought to its logical conclusion in terms of the aforesaid judgment dated so-and-so by resorting to the procedure prescribed under subsection 3, section 22 of the Administrative Tribunal Act. Even today, both the parties are at loggerheads, where one party claims to have fulfilled the condition precedent for conferment of temporary status as temporary Mazdoor, where the other party fiercely denying the same. On the above count, we have no option but to remand the matter to the tribunal once again for resolving the apparent dispute by taking recourse to the procedure prescribed under subsection 3 of section 22 of the Administrative Tribunal Act 1985. On the finding above, we allow the 4 petitions by setting aside the common order of the tribunal dated so-and-so. Since the dispute between parties are long pending one, we hope and trust that the same would be brought to its logical determination by the tribunal as expeditiously as possible by following the procedure as indicated above. In this regard, the concerned transport application or original applications be restored to file for a de novo hearing and judgment thereof. So basically, this Honorable Court said that the tribunal did not take evidence. Without taking evidence, come to a conclusion. So again, remanded back. Now, thereafter, my lord, we produced evidence before the tribunal, and the finding of the tribunal with regard to the present petitioners, that your lordship will find the order impugned at page 365. It starts at page 365. Since various OAs, several OAs were taken into consideration, so far as our details are concerned, present petitioners' details are concerned, I'll take your lordships directly to that portion. Page 365 is the order where it starts. And the conclusion or findings recorded by the learned tribunal with regard to the present applicants, present petitioners.
Page
412. Learned tribunal, my lord, while deciding the other cases.
412.
Yes.
Yeah.
In TA number 59/2009, Milo, this should have been TA 62. This was Milo typographical error by the learned tribunal.
all the applicants produce some statement and certificates as follows. Serial number 1, certificate dated so and so showing Dhanapati Locker completing 244 days from May 1995 to December 1995.
Yeah.
Findings of verification committee establishing that Sri Ajit Chandra Das completed 240 days from March 1993 to December 1993, 277 days from January 94 to October 94, 241 days from January 95 to October 95, and 305 days from January 96 to October 96. Now, this findings of verification committee is not our document, Milo. This was a verification committee constituted by the respondents, and that verification committee gave this finding. Finding of the verification committee establishing that Sri Mohan Chandra Das completed 105 days from April 94 to 95, 91 days from April 96 to June 96, and 151 days from January 97 to September 97. Finding of the three-member committee establishing that Sri Mohan Chandra Das completed 30 days in April 97, 30 days in June 97, 31 days in October 97, 9 days in November 97. Certificate dated so-and-so establishing that Sri Torani Boro completed 240 days from October 94 to June 95. Certificate dated 17/8/97 establishing that Sri Torani Boro completed 94 days from August 95 to December 95. Certificate establishing that Sri Torani Boro completed 104 days from 98 to from February 98 to May 98. Finding of the verification committee establishing that Muhammad Bainur Ali completed 144 days from October 93 to December 94, 170 days from February 95 to July 95, and 275 days from January 96 to December 96.
Up to this point number 11. These are the up to Roman 11.
Yes, my lord.
This is in relation to these
Present petitioners.
Now, the respondent in their evidence.
Yes, my lord. The respondents in their evidence on affidavit stated that the applicants failed to produce the original documents and all the exhibited documents are type copy without any reference to original one and same are not authenticated. Now, first of all, my submission with regard to original, my lord, will never be able to produce original.
How the learned single judges dealt with this? This
Tribunal.
OA, sorry, not learned single judge, the tribunal.
Yes, my lord. The learned tribunal has finally decided para 30.
30, okay.
Yes, my lord. While exploring the details of pros and cons, each and every cases of the applicants were found that the respondent BSNL vociferously argued on their evidence on affidavit that all the applicants exhibited papers are type copy, not authenticated, and all the applicants failed to prove by displaying the original one so as to prove the type copy or any photocopy are genuine as per the Evidence Act. This was, and finally, the learned tribunal at para 42 derived conclusion after taking into entire conspectus of the case, we find that the verification committee, which is legally constituted, had duly considered all the relevant materials placed before it by either side. The applicants have failed to make out the case by establishing even evidence on affidavit. Accordingly, we are in view that the applicants failed to satisfy the requirements of Casual Labor Grant of Temporary Status Scheme 1989 scheme for conferment of temporary status and regularization. In view of the above position, the applicants' claim seeking implementation of Casual Labor Grant of Temporary Status and Regularization Scheme 1989 in their respective cases are not enforceable under the law. As such, the present applications, that is TA and OA, are devoid of merit. Accordingly, same are dismissed.
Yes.
So if your lordships considers the documents that we produced, those are not all photocopies, madam. We have given type copies of the documents, which were Xerox copy we had with us, my lord. Page 175.
onwards are the documents, my lord.
One seventy-five.
Yes, my lord. These were the documents exhibited before the learned tribunal. No, these were the only documents we have, my lord, to substantiate our claim. 175 is with respect to Dhanapati Law Court. Then page 176, it's a type copy, yes, but type copy of page 177, my lord, which is a finding of a verification committee. Then page 178 also is a verification committee noting. Page 180. Then 181 is the type copy of 182. Yes, and till date they are working, my lord. It's not the case like the other applicants before the learned tribunal that 1998 they were discontinued. Till date they are working, my lord. So even after, my lord, 28 years of service, if they say that they haven't completed 240 days of service, my lord, then it will be absolutely unfair, my lord. Because I cannot create, I am not the custodian of the documents that learned tribunal has come to a conclusion that the documents are not original, my lord. I being a casual laborer, already, my lord, my access is tremendously limited to get any document. Somehow we got these documents and we place it before the learned tribunal. We'll never be able to produce original documents.
To move an application before the tribunal to ask them to produce the original. They can very well move an application for production of those original documents of these.
But yes, true, your lordship is correct, but
Simply,
once
yes, admittedly, these photo state copies are not are not admissible in evidence.
But
in the absence of that, either you could have moved an application under section 65 to allow you to produce the secondary evidence and something else. That was not there. In the absence of it, only on the basis, yes, it is photostat copy. But since the original was there, not there, you can very well move an application before the tribunal to compel the authorities concerned to produce the originals of it, or you can move an application to allow you to produce the secondary evidence of this section 65 application was there.
Actually, under the rule section 22(3), when the matter was remanded back, so we were directed to place the evidence in the form of an affidavit. So we produce the evidence in
Apart
affidavit.
from that, they have also said they can resort to after taking into consideration of section 3 of section 22.
Yes,
All the powers of the civil court. So
that's there.
That's there. In the absence of it, now it's very difficult for us to come
But the
to a
fact
conclusion
remains-
on the basis of these documents, which are certainly not admissible, and without there being any effort on your part to produce the original, to compel the respondents to produce the original.
Now also, my lord, the respondents, they are the custodian of the records, my lord. They can produce the records. Since 2000, my lord, these people are praying for this benefit.
Still they are working.
Still they are working, my lord. Some of them will attain the age of superannuation, my lord.
As far as the. Become more complex.
Yes.
Hello, as far as the records are concerned, Lordship had put a query basically. That of course it was for them to actually produce evidence or call for the records. The power to call for the records was there. In this case, in fact, Lordship had seen that there was a series of cases, in fact, this particular OA I was not representing because ETR, my lord, was a different zone. I was not their lawyer at that point of time. But in the other cases, what I have done is that, my lord, at the time of filing of our evidence, we had produced the original records before the tribunal.
No,
But then in this case, it was not there. My lord. In this particular case, it was not there. And on the basis of whatever material
It
that
is
was
in
there.
relation to 4-5 persons. How many persons are there?
Seven, my lord. Seven.
So whatever it may be, ultimately, since they have either you should have produced, yes, certainly, the originals was not there. Either you deny this, that no such original of this document is there, then matter ends there.
Hello.
But if there is no denial, specific denial by you, because mainly the tribunal has passed that all these are type copies, and therefore we are not going to consider those, that is not sufficient to prove that. But here they have produced, in almost all 7 cases, they have produced the photostat copies of the purportedly that original, not the original can't say. You have to confirm that.
Right.
Whether that is there or not.
Can be done, my lord. What I have seen, my lord, from the records is basically that what prompted the BSNL to not give them the TSM status was that the cutoff date of 1998. At that juncture, my lord, unfortunately, they were not in engagement. They were left out. Subsequently, some of them again got engaged, my lord. But then that cutoff juncture, at that particular point of time, they were not in.
Clarify this situation, please. You clarify this situation. On the next date of hearing, you clarify.
My lord.
Because the documents starts from
Page 187.
187.
Sorry, my lord. Uh,
Should be
175, my lord.
175.
175.
175. And 175 onwards regarding these 7 candidates.
Yes, my lord.
We give this. Submit this.
And in fact, my lord,
Okay. Now, the concept of the petitioner has submitted that along with the OA number 62/,
it's TA number, my lord. TA number,
TA number.
it
No,
should be,
Because the
TA
matters were
number
transferred.
62/2009 in WPC number 88886/2005. The petitioners have submitted photo-state copies of the statements. Photo-state copies of the details of their engagement as details of their engagement as casual labor, as well as the report by the verification committee. But the tribunal has but the tribunal, without considering the same, has rejected the claim of the petitioners, stating that they have filed only the typed copies. It is submitted by the counsel for the petitioner that the tribunal, that the respondent BSNL has not denied before the tribunal regarding the existence of the said photo state documents and in such circumstances the tribunal has illegally rejected the claim of the petitioners of grant of temporary status. It's for the next counsel appearing for the BSNL raised some time to confirm regarding the existence of the photo state documents produced by the petitioners in support of their claim before the tribunal. Time prayed for is granted. List on. Eighteenth of July, sorry, 18th or 15th. Twenty-fourth of July.
fine,
24th of July. 24th is not the hearing day, na?
no, it's Wednesday, I think.
It's Wednesday.
25th of July.
25th, perhaps, my lord, is having a bench with Honorable Justice Shuman Sham with regard to Sikkim matters, my lord.
Okay, then 23rd.
23rd, yes.
23rd.
Time might be too short for me, my lord.
Try it.
My lord, we try.
23rd.
Right.
Item 41.
In this case, I'm appearing for the petitioner. The counsel for the respondent, senior counsel,
Yes,
Yes,
Actually, my lord, he's out of station. Yes, lordship may kindly pick this.
Item 42.
My please, Lord, my lord, in this case, I am there by Mr. D. Das, my lord, senior advocate. So, my lord, some personal difficulty today, my lord. May I?
Why don't you argue?
My lord, the client.
You are quite senior, you argue.
Actually, he has been engaged, my lord, by the client, my lord. There's a difficulty, my lord. So on Wednesday, my lord, if not.
We'll decide the matter and will show his presence in the order. You argue it.
My lord, he is required.
He's engaged, I think, sir.
Wednesday, my lord.
On next Friday, Lordship.
Friday, hearing day, on the
Then-
hearing day will.
And Lordship, from tomorrow onwards, special division bench is there. I have to assist the SG Lordship regarding rules and
Is there any urgency in the matter?
urgency is there, Lordship.
Why?
Regarding Lordship, parcel one, Lordship, we are not able to even, my Lordship directed us to Lordship, the e-tendering Lordship, that was also not
You
able.
are for the appellant.
No,
I'm
Lordship,
for
I'm- he is for it.
Is there any interest?
No,
No,
Lordship.
No, my lord.
As there is stage there, Lordship. Although my lord has directed us to Lordship e-auction, Lordship, and Lordship said, observe that e-auction is subject to the outcome of the repetition, Lordship. But e-auction process, Lordship,
Post order, that is always there, even though if the.
Lordship, on order dated 24/8/22, Lord. My lord may kindly pay us 24/8/22 order. Even Lordship has directed them to Lordship. The carry out the Lordship parcels, that was also, they have not
The
done. Lordship.
it is already provided that the railway will proceed with the floating first, but same will not be finalized without leave of the court.
Because
It is still not finalized.
Lordship, e-auction, Lordship, we cannot proceed, Lordship. We, if it is proceed, Lordship, then automatically it will be Lordship finalized.
Friday.
Lordship, on Friday, Lordship. Oblige, Lordship.
Difficulties in the.